This is Mark Strassman, reporter with Etopia Media's California Politics Today. We're about to speak to Russell Korobkin, who is a professor of law at UCLA Law School and a senior fellow at the UCLA Center for Society and Genetics. Welcome to Etopia Media's California Politics Today.
Thank you, Mark.
You recently wrote an op-ed piece for the Los Angeles Times entitled Stem Cell Initiative Sabotaged. Could you give us a brief synopsis of what you said and why you said it in that op-ed piece?
Sure. Well, as you know, Mark, that since Proposition 71 was approved by the voters in 2004, the bonds that would be issued by the state to fund stem cell research have been tied up by ongoing litigation over the constitutionality of the initiative. And the point of my op-ed piece was that to argue that the litigation is essentially frivolous litigation that doesn't have a legitimate chance of succeeding on the legal merits and is rather an attempt to delay the sale of the bonds. And you know, I implied, if not said explicitly, that I think that this is an abuse of the legal process to make arguments that are really as legally weak as I believe the arguments that the plaintiffs are making in this case are.
Why do you believe that they're proceeding, even though, as you say, their arguments are weak?
Well, I think that the folks that are opposed to stem cell research in particular are interested, even if they don't ultimately prevail in the court proceedings, at preventing the funding of stem cell research in California for as long as possible. And they know that because the court system moves very slowly and very deliberately, that by litigating this matter and by then appealing this to the appeals court and hopefully from their perspective, the California Supreme Court, that they can potentially delay the research that they don't want to see happen for several years.
How successful have they been so far in delaying the research that you say they don't want?
Well, I think they've been extremely successful so far that we still don't have an outcome of the trial court decision. And of course, the initiative was passed in November 2004. It's now almost the end of March 2006. So they've been able to delay things for about a year and a half already. They were able to convince a trial court judge in Alameda County to actually give them an opportunity to present evidence at trial in this case, even though, from my perspective at least, their legal arguments were so weak that the judge could have and should have dismissed the case many months ago. So just by getting the ability to present evidence at trial, they were able to drag out the proceedings for a number of months, and they've said that even if they lose in the trial court, that they plan to appeal and appeal again until all of their appeals run out.
If we could, why don't we address the substantive issues that are being argued in this case, giving their point of view first.
Sure.
What's the argument that's being made by the plaintiffs in this case about the constitutionality of the institutions established by Proposition 71?
Right. So the first thing, it's important to understand that that they have to demonstrate, in order to get the initiative thrown out by the courts, they have to determine they have to convince the court not that the initiative is bad public policy, but that it actually violates the California Constitution. And so they've made a number of arguments to try to convince the court of this. And the one that's gotten the most press and is actually the lead argument in their legal briefs is that the California Institute of Regenerative Medicine that's set up by Prop 71 lacks sufficient state oversight and therefore violates a provision in the California Constitution that requires state agencies to be under the exclusive management and control of the state.
That would be Article 16, Section 3 of the California Constitution.
That sounds right to me.
Right. And months ago, maybe years ago, or more than a year ago, I interviewed Professor Calvin Massey at Hastings College of Law about this particular point when it was first raised.
Yeah.
And he said that there was nothing to it because there was an existing exemption for state institutions that were established for public benefit purposes. That argument has never surfaced on either side of this discussion. I'm wondering what you know about that precedent and why it may not have come up in the discussions or the briefs back and forth.
Interesting. So I'm not sure exactly what Professor Massey would have been referring to, but it is the California courts have said on a number of occasions, and most recently and forcefully in 2003 when they were considering a challenge to a different initiative.
Rob Reiner's So You're Echo.
That's right, Rob Reiner, the Proposition 10. And the California Court of Appeal said, look, that the exclusive management and control provision is essentially to protect against individuals having control over state money to the extent that they can use that state money as their private piggy bank for their own personal gain. But it doesn't prevent the state from experimenting with creative administrative structures.
Ironically, of course, Rob Reiner's under some scrutiny lately for using funds from that, I think from that fund or from another one, for what some people are arguing are partisan or personal political purposes.
Yeah, absolutely. And I think the key point here is to recognize that there's an important difference between the initiative being unconstitutional and, on one hand, and officials, state officials running an administrative agency behaving in a way that might be contrary to law. That in this case, in order to get Proposition 71 thrown out, the plaintiffs would have to prove that in this particular case, the way the agency is designed and set up doesn't provide enough management and control.
Okay, well, why don't you give the arguments from the Attorney General, who's representing the defendants in this case, Bill Lockyer, his office, as to why the ICOC, the Independent Citizens Oversight Committee, and the California Institute for Regenerative Medicine, the CIRM, which it oversees, are under the exclusive management and control of the state of California.
Yes. Okay. Well, first of all, almost all of the members of the ICOC, with the primary exception of the two chief officers who are elected by the other officers, and then I believe there are 5 members of the ICOC that are appointed by UC chancellors. All of the rest of the members of the ICOC are appointed by elected state officials. So that's one way in which the state maintains management and control over the agency. Elected state officials choose the people that are running the agency.
Could you explain the logic by which the appointment to the board, the governing board of this organization, by an elected state official provides for management and control by the state, since once they're appointed, there may be no way to recall them or remove them or to give them orders as to what they're supposed to do?
Yeah. Well, I think it's a totality of the circumstances type of issue. So it's not just that they're appointed by elected state officials, but also that there's a substantial amount of state oversight in terms of the state controller's office auditing and reviewing the expenditures of the of CIRM.
Okay, well, talk about that in more detail. What is the authority, and has it been exercised yet by the state controller's office over the budgeting process or the substance of the budget of the CIRM and the ICOC?
Well, as I'm sure you know, Mark, and you might know more about this particular point than I do. There's been this ongoing battle with some members of the state Senate over a desire to have an audit done at this point of the agency.
That would be State Senator Deborah Ortiz.
Right, she's the one leading the charge.
Right.
Yeah, absolutely.
And in fact, she and 10 other members of the legislature asked for and got the state auditor to do a performance review of the organization. That's in addition, though, to the audit that you've referred to from the controller's office. Yeah.
Well, these are and these are both examples, I think, of how there are in Prop 71 provides a structure that ensures that there is state oversight of what's going on.
Doesn't the Constitution say management and control rather than oversight?
Well, yeah, but remember that I think the key point here is that the case law where the California courts have discussed this issue have said that this is not meant to put a straitjacket on the state in the way that the state wants to establish administrative agencies. All it's that the California Constitution allows for the state to do all kinds of different things in terms of how they structure an agency and what kind of power they give to an agency. The purpose of that clause of the Constitution is to make sure that no private citizens can use state money for their own personal benefits. That, I think, is the critical bottom line. And there are enough procedures in place that given the court's decisions, especially in the Prop 10 case, where the structure of the agency in that case is not the same as the structure of CERN, but it's similarly unorthodox, and the court in that case, like I think the courts in this case will say, that look, this is unorthodox, but the voters of the state have the right to establish unorthodox administrative agencies, as long as this is not an initiative that effectively takes public money and puts it into the private pockets.
Okay, well, we may talk a little bit about that, whether it does that, but what you're saying then is if the members of the ICOC, the governing board, the Independent Citizens Oversight Committee, chose to, for example, grant Ed Penhote, the vice chair, $1 million to do a particular kind of stem cell research or for any other purpose, that would be overseen by the controller's office, who would then take action to block that. Is that what you're saying?
Well, I'm not sure of how internally that would work. But there are the third point I was going to make, in addition to the appointment of by state officials and by the oversight of the auditor's office, is that the state controller's office, is that the under the provisions of Prop 71. And these are not spelled out in great detail, and the ICOC does have some control over these, but it makes clear that scientific decisions, the decisions about who's going to get research grants, are going to be determined by a type of scientific peer review process. So if there are...
You're referring to the working groups.
That's right. That's right.
Now, some arguments have been made, I think they're made by the plaintiffs in the case, that those working groups are totally outside the control, let alone the exclusive management and control of the state of California. What do you say to that argument?
Well, but ultimately it's the ICOC that will make the final decisions. And again, these are the folks who are appointed by elected state officials and are overseen by the controller's office. Look, in any kind of administrative agency, there are going to be officers who are in positions to make decisions about how state money is spent, who are not themselves directly elected by the voters or are not subject to recall.
Aren't they in any case subject to firing by people who are subject to firing by people who are elected in any case? In every case except for this?
I'm not sure if that's true in every case or not.
I just thought of one other sort of counterexample here in terms of being appointed by an elected official demonstrating control. The President of the United States, with the consent of the Senate, appoints the members of the U.S. Supreme Court, who are most definitely under the U.S. Constitution, not subject to the control of either the executive branch or the legislative branch.
That's right.
So I'm wondering how the argument that the members of the ICOC, who are appointed by elected officials, are under the control of whom exactly, as agents of the state who are themselves elected by the people of California.
Well, I think that again, it's the collection of provisions of the appointment of the oversight by the controller's office of the scientific peer review process, that if money were, for example, that again, without getting into the specific details of Proposition 71, but if money was allocated for a purely private purpose, let's say not given for legitimate stem cell research, then that would constitute a violation of the statute, and there would be legal remedies to prevent that from happening. Now, granted, the conflict of interest rules that would normally apply to state officers are weakened in the case of CERN. So it is possible that, for example, I think one criticism of the law that is a very fair criticism is that people who are trying to get grant money to do stem cell research will, in some cases, have some role in the decision-making process about who gets money.
Well, is that a conflict of interest? It seems that under the provisions and the facts of the members, I set up a spreadsheet today with the members of the ICOC and saw their institutional affiliations. Doesn't that represent essentially, if not a comprehensive similar list, a strong cross-section of those organizations in California that are in line to get the stem cell research money that the ICOC, made up of these people who are from these organizations, represent? Isn't that a conflict of interest?
Yes, it's absolutely a conflict of interest, but it's not. it's not a constitutional violation for the voters of the state to set up an institute where there are these conflicts of interest.
Okay.
That as long as they're not, where there would be a problem under the state constitution is if it were possible for these individuals with a conflict of interest to actually be taking millions of dollars from the state for their personal use.
But if they give it to their institutions, the University of California, to Stanford, to UCLA, to biotech companies,
right,
that's not equally egregious conflict of interest?
It might be an equally egregious conflict of interest, but it doesn't violate the state constitution as long as
And what recourse do the people or the elected officials of California have to prevent those conflicts of interest under the structure that Prop 71 set up?
Well, there are. CIRM has the ability to, the ICOC and CIRM have the ability, as I understand it, to set up their own conflict of interest rules. Now, assuming they don't do anything.
Well, they have, and they're doing it. They spend a lot of time doing that. But
Right.
people in the legislature, Deborah Ortiz in particular,
Right.
don't think they're doing enough.
Right.
And does she have the authority? Does the legislature as a whole have the authority? Does the governor have the authority to require the ICOC to follow the priorities or principles that they would like to see them follow?
My understanding is no, they don't, at least for a 3-year period, after which the statute that was approved by the voters in initiative form can be amended by the state government. At
With
that
a 70% vote.
Right, that's right, with a supermajority.
Okay. We've been talking about some fairly minute, and there are even more minute ones that we haven't talked about, points of law here.
Yeah.
But I wanted you to sort of pull back and address this sort of more general question. The group we've been talking about is the Independent Citizens Oversight Committee.
Right.
That's right?
That's right.
What's it independent of?
What's it independent of? Well, I think so you're asking me why they've labeled the name of the group with the word independent.
That's
and
right.
I think it's meant to suggest that they are. It's supposed to be a group that will make decisions based on their scientific merits, independent of political pressures.
Political pressures. What's the difference between political pressures and the exclusive management and control of the state of California?
The difference is that decisions that, it comes down to how broadly or how narrowly that clause in the state constitution is interpreted by the courts. And the argument that you're making, I think, would be a very fair argument if this issue had never come up before the state courts before. You look at those words, exclusive management and control, and just based on those words, I think it's a very plausible argument that more effective control by elective officials on a day-to-day basis would be necessary than are granted under Prop 71. But the key here about my argument about why this litigation should not be permitted to go on is that this issue has been decided in past cases where the courts have said that this provision is supposed to be read to provide only the most minimal restrictions on how much power and authority the state can grant a state agency.
Okay. From what you know about the history and politics of the creation of Prop 71, and the people who did it and why they did it and what they said about what they were doing when they did it, didn't they call themselves the Independent Citizens Oversight Committee because they wanted to be independent of the state's control of their decisions about where the research money for human embryonic stem cell research money should go?
Well, but they are part of the state apparatus. I mean, they are state officials.
But who do they answer to as state officials? The members of the legislature have to be elected. The governor has to be elected. The heads of all the other agencies serve, as I understand it, at the pleasure of the executive. Aren't they independent of all of those controls? The board members of ICOC and therefore the CIRM?
They're not independent of. Again, if you were, I think you make a fine argument if we're arguing from first principles over how that provision of the Constitution should be.
But you're saying that given the case law, the precedent,
that's right,
that this is an established principle that limited amounts of control amount to meeting the constitutional provision.
Absolutely right, and I think the touchstone again is whether or not the structure would allow for individuals associated with the agency to actually use it as, I believe one of the courts said at one point, although I can't recall the exact wording, but the idea was that the state can't put individuals in charge of state money with the ability to then take the state money and use it for their own private purposes, not associated with state business. But that beyond that, the exclusive management and control clause should not be read so broadly as to restrict the state's ability to experiment with different administrative structures. And in this case, yes, more authority is given to the agency than most state agencies. That's absolutely right.
And essentially what you're saying then, as long as they don't spend the money directly on themselves for, say, golfing trips to Scotland or something, if they want to spend it on, they want to give it to Irv Weissman at Stanford to make mouse-human chimeras and put human nerve cells into mice and say that they're going to kill them if they start applying for grants themselves, the mice, that they can do that if they want.
Yeah, I believe
and nobody that's right. And nobody in the state government can stop them.
That's right.
Okay,
that's right. I think that's right.
Okay,
but if they were to use, the key is if they were to use the money to finance their own golf trips, as you suggest, then I think they violated the statute, and then legal action.
But they're free. They're free, as you read it, under the Constitution and of California and precedent, to spend the money however they want, as long as it's for the purpose of doing embryonic stem cell research and related purposes.
Pretty much, and within the confines of a few other specifics of the statute.
I'm not sure it's within your purview, but I would like you to address, if you want to, some of the other criticism outside of this that have been made about the whole Proposition 71 complex. In particular, the promises that were made by the supporters of Prop 71 that helped get it passed, and which haven't really borne the kind of fruit that they promised. In particular, the delivery of up to $1.1 billion in money from royalties, from patents, that would be generated by research done with money raised by tax-exempt bonds that would then go to the coffers of the state of California. What's the status of that, as you understand it, and how legitimate a tactic do you think it is to bait and switch something like that?
Well, as to whether it's bait and switch, I'm afraid I'm not an expert enough to say. What I do think is that it seems to me very unclear at this point how much money these bonds will generate in returns for the state of California. I think it's possible with the given structure that it could be a lot of money. It's possible that it could be very little money. And so I would be hesitant to make any claims, as I know the supporters of the initiative did, about the exact amount of money that this is going to raise for the state. I just don't think we have any idea. It's possible that if the state funds research projects that turn into fantastically successful commercial ventures, that with the rules that have been passed about sharing some of that revenue back with the state, could be a lot of money. So might be almost no money.
The way that's looked, as I've followed that discussion, is that the biotech companies that would be commercializing this have said that if they have to pay too much in royalties, it's not going to be worth their while. They're not going to do it.
Yeah, I think that's.
We didn't hear that before the election.
Well, yeah, I think that's quite possible. And I'm not going to, I'm not trying to either defend or disparage the people that were pushing the initiative. I think it would. I think it's certainly the case that given that we know very little about how stem cell research is going to play out, and how the funding of stem cell research by these $3 billion of bonds are going to play out, I think it would be it's incautious to make predictions or make promises about how much money that's going to bring in, and I personally wouldn't recommend doing that.
Okay. There were also promises made about how individuals and the state would save a lot of money after these cures were found and these treatments. Does that still seem plausible to you, given how expensive some of these treatments are likely to be once and if they're developed?
I think it's possible, but certainly far from definite. If you imagine, let's say that a cure is, let's say that some stem cell treatment is found that will mitigate the effects of Alzheimer's disease, just as an example. So on one hand, the treatment will probably be very expensive, although nobody knows for sure at this point. Probably be very expensive. On the other hand, the state might save a lot of money in Medicaid payments for long-term care for Alzheimer's sufferers who otherwise might have to be institutionalized.
But you're saying that it's pretty hard to tell.
It'd be impossible to make an educated guess about. And then on the other hand, people, if some finding cures for some diseases might save money in treatment of those diseases, but might enable people to live longer, which will cost the state more money down the road in treating them for illnesses that they get later on in life. How that all nets out, whether it's going to be a net savings or a net cost, I don't think anybody could make any kind of reasonable promise about how that'll play out.
Okay, say a little bit about the center, the UCLA Center for Society and Genetics that you're a senior fellow at.
Sure.
Its function and role.
Right. So the center was set up a handful of years ago by the chancellor at UCLA to try to bring together scholars from different disciplines in the university to study the social implications of the boom in genetic technology that we've seen over the last decade or so, with starting with the Human Genome Project and a lot of the advances in genetics. Historically, at UCLA and many of the other UC institutions, we've had very strong scientific programs, but there hasn't been a large study in the social sciences and the humanities that brings together the science and the ethical and legal issues and social implications about these emerging technologies. So that's what the center brings together fellows and faculty to try to study those kinds of issues.
Okay, would one of those issues be egg donation, egg farming, and the ethics of extracting eggs from women to do the embryonic stem cell research that's at issue here?
I think that's a very big issue in sort of the crossover between genetics, genetic technology, and ethical and social issues. Absolutely.
Where does that stand now in terms of the procedures that the ICOC are putting in place, the ones that otherwise exist? And I read some testimony at the Illinois legislature made in the past year by an opponent of this research who calculated the human cost and the financial cost of collecting enough human eggs from women in order to do the somatic cell nuclear transfer research that's at the heart of this whole proposition.
Sure. Not
to mention the treatments, the individualized treatments that Dr. Huang it seemed to be on the brink of developing, but turned out not to be.
Right.
But that would require essentially at least one human egg for every individual who was treated, assuming you were getting a 1-to-1 ratio between attempts to generate specific individualized stem cells to treat patients.
Yes.
What's the status of that, and what are your views on the ethics of all that?
Right. So in terms of, you raise a number of very important and difficult issues. Let me try to address them. In terms of how many eggs would be necessary for these kind of treatments that you're talking about, that's another question that I think is so far in the future that we don't have any idea. If it turns out that treatments for diseases will require developing an individual stem cell treatment for each individual that has the illness, based using that individual cells.
A skin cell from that person and an egg cell from a donor.
For example. Yeah. If that's necessary, then you're right that lots of eggs would be needed for that. If it turns out that treatments are developed not on an individualized basis, but certain treatments can be developed from a line of stem cells that can then be used for a lot of different people, then a lot fewer eggs would be needed. So I think we don't know how many will be needed down the line. That said, we're probably going to need either a moderately high number or an extremely high number.
What about paying women
right.
to contribute these eggs, to give them some of the financial rewards if their eggs lead to are used
yes.
in experiments that lead to cures or treatments?
Sure.
And what about the fact that women can get $10,000 for an egg for an infertile couple, and as I see it right now, they're expected to donate these for cab fare for research purposes.
Well, this is. I think I agree with your implication here that I think this is a tremendous problem that CIRM has stated, and this actually, though, wouldn't be fair to say is a decision of CIRM exactly, because the Proposition 71 specified this as well, that women should not be paid for the donation of eggs. They can be paid only for direct expenses, like you say, cab fare, for example. This is, I think. This is consistent with how I view the majority of ethics in the medical research community view egg donation, that it would be unethical and inappropriate to pay women for this. I personally think that is. I completely disagree with that analysis. I think exactly the opposite for both ethical and practical reasons. As you suggest, if we were asking women to donate eggs purely from altruistic motives, I don't think we're going to get very many eggs, because donating eggs, as you know, is not an easy process. It's not pain-free.
I certainly don't know it from personal experience, but from the literature, I understand it can be dangerous.
It can be dangerous.
We only have about 3 minutes left, and I want to address a point that was a surprise in your piece when I read it.
Yes.
You say that in 2008, whoever's elected president, they're probably going to change the federal prohibition that President Bush put in August of 2001 that led to this whole proposition.
Right.
If that's the case, what evidence do you have that is the case?
Right. So the only evidence is that most of the likely contenders for the nominations of both parties, not all.
Bill Frist, for example, wouldn't fall into this category, would he?
Oh yes, absolutely. Bill Frist has come out in favor of stem cell research.
Well, are there any major candidates who want to continue President Bush's prohibition on federal funding?
Well, I know.
Research?
Well, it depends on who you consider a major candidate. I know that Mitt Romney, who may or may not be considered a major candidate, I know he is opposed to stem cell research, so he might be one. But if you look at the field of likely nominees on the Democratic side and on the Republican side, most of them, again, not all, but most of them on both sides of the aisle are in favor of stem cell research. And so it's likely, I didn't say it's absolutely certain, but it's likely that whether the Republicans or the Democrats win in 2008, that the Bush prohibitions on federal funding will be repealed.
Okay. In the less than 2 minutes we've got left here, talk about the impact of that in the context of the delaying tactics of the opponents of Prop 71. Are you asking them in your piece to essentially withdraw their suit, or do you expect that they will? And if they don't, how long do you think it will take to be finally resolved at the Supreme Court of California level? And if so, what's the relationship between that and that could be 2007? And if the candidates are coming online in 2008, running and saying they're going to change that, what does that do to California's position as the putative head of the human embryonic stem cell research movement? And you've got 1 minute to talk about it.
You've asked a lot of good questions there, Mark. Okay, so first of all, the litigation, I don't expect them to withdraw the litigation. What I would hope is that the courts would move more quickly to resolve
How quickly
the
could they act?
Once the trial court issues its decision, which could happen any day now, the Supreme Court of California could step in and take the case directly on its own motion or on the motion of the parties and not have it go through the Court of Appeals
Would you like it to do that?
I think it absolutely should do that.
If it does that, what's the shortest time it could take to resolve the case?
Well, I think in theory it could be done in a couple of months. In reality, I would say probably 6 months would be the shortest possible time.
Okay,
but that would be a lot less than the 2 years it might take to go through the Court of Appeal and the Supreme Court. In terms of your other question about the impact on California, is that when federal money comes online, California's money will be much less valuable to researchers, and so California will have much less of an advantage in stem cell research.